Court is on the record in the City of Conneaut versus Keith Garvin, 25 CRB 91. On April 7, 2025, Mr. Garvin pled not guilty to one count of domestic violence, a first-degree misdemeanor. We conducted a first pretrial conference on April 14, 2025. This case is set for a second pretrial conference today. In the meantime, on April 29th, 2025, the law director filed with the court a motion to revoke Mr. Garvin's bond. And so the court also, in addition to the pretrial conference today, the court also set this case for a hearing on the motion to revoke. This case was set at 9 a.m. today. The defendant was given notice of the hearing today. We have a signed receipt in the file show he was given notice at his last pretrial conference. It is now 9:16 a.m. and the defendant, Keith Garvin, has failed to appear. Present in the courtroom is his attorney, Philip Heasley, law director John Lewis, and Officer Pinkett of the Conneaut Police Department. Mr. Heasley, can you advise us to where your client is?
Yes, Your Honor. Thank you. My client's whereabouts are currently unknown to me. I will say for the record that notice letter for him to be here today at 9 a.m. with the time and date in bold print did go out to him. And we have not heard from him, Your Honor. And furthermore, as of today, I have been provided with additional discovery regarding the alleged incident regarding the bond revocation hearing. So, unknown, Your Honor, and I'm sorry to say that. Thank you very much.
Have you attempted to reach him this morning?
I have not done that, Your Honor.
I thought you told my bailiff that you attempted to call him this morning.
Not this morning, Your Honor. So, I'm sorry if I indicated that. No, that was...
Do you have a good contact number to call him?
I will check, Your Honor.
You know, Mr. Heasley, if your client, and it happens fairly frequently, when your client fails to appear and you have contact information, you shouldn't have to wait for the court to tell you to call him.
Yes, sir.
I mean, you've been doing this long enough to know to get on the phone and call him even before we go in the courtroom. Don't even worry about it. He's not here. I'm revoking his bond. I'm issuing a warrant for his arrest. No bond will be imposed on that warrant. We'll reschedule anything in this case until the defendant is incarcerated and the warrant is executed. You know, for the benefit of your client, you may want to do that in the future, but too late now. I'm revoking his bond and issuing a warrant.
And, Your Honor, I don't see a phone number in our contact information for what that's worth. So, on will issue. Thank you. Thank you.
Anything further, Mr. Lewis?
Oh, no, Your Honor. Thank you.
Okay. This matter is concluded. I'm sorry that all the witnesses are inconvenienced.
Mr. Garvin, have a seat.
Court's back on the record. City of Conneaut versus Keith Garvin, 25 CRB 91. Mr. Garvin comes strolling in at 9:25 a.m. Case is set for 9 a.m. Where you been?
Home.
Excuse me? Home. Take him into custody, hold him, and then we'll make you think about being on time. Seriously. We're revoking your bond. Tired of people being late. I've got a full docket today. Full docket. You know you're supposed to be here at 9. Okay, the court is back on the record in City of Conneaut versus Keith Garvin for the third time. Case number 25 CRB 91. The court instructed Officer Pinkett to bring Mr. Garvin back up from the jail so we can proceed with today's hearing and pretrial conference. Mr. Garvin is present He's accompanied by his attorney, Philip Heasley. Also present, Law Director John Lewis and Officer Pinkett sitting at the Law Director table. Mr. Garvin, does your attorney know how to get a hold of you?
I left like 4 different voicemails.
You left him 4 different voicemails? Does he have your phone number?
Like have his contact number.
Write your phone number down. You got it?
Yes, sir.
Okay, that's good. Because earlier, a few minutes ago, Mr. Heasley reported he did not have contact information for you. So, when did you leave these 4 voicemail messages?
I believe the first one was the day after court. That was the 18th.
Do you guys even have voicemail at the public defender's office?
We have voicemail, Your Honor.
I'm not even going to get into that.
Okay.
You know, if this is true. Because now I'm really steaming. Why were you late today?
I thought it was at 10. I thought I was here 30 minutes early.
Yeah, well, I've got a signed receipt in the file showing that you signed a receipt with a 9 o'clock a.m. hearing date, or hearing time. So, you were wrong that it started at 10. Okay, counsel, have you guys talked about possible resolution, or are you ready to proceed with the hearing on motion?
I'm ready to proceed, Your Honor.
Okay. Mr. Heasley.
Thank you, Your Honor. We have just been provided with information regarding the revocation
What do you mean just provided?
earlier this morning from the prosecutor, Your Honor.
Well, you knew this hearing. You knew today was also scheduled for a hearing on the revocation, though,
Yes,
right?
sir.
Okay. So you're talking about like discovery information?
This is on an alleged incident from April 20th.
When I ask you what were you provided today with, is it discovery information about the revocation issue?
Yes, sir.
Okay. So what are you asking?
And I do realize the court has its schedule a minute or two to speak with Mr. Garvin regarding the revocation and whether he would admit to the same. And if not, we're prepared to have a hearing. Thank you.
The facts here warrant, blatantly ignoring the court's order not to have contact with Ms. Martini. I would ask the court, I realize the jail is pretty full right now, but I don't know what other, obviously the court order is not going to work to keep Mr. Garvin from having contact with her. And I did discuss with Ms. Martini the fact that she's not to have contact with him either, in respect of the court order. So I did explain that all to her, Your Honor, as well. I indicated that Mr. Garvin has the rights of a tenant currently in that house, even though he's not, I don't know if he's paying rent or not, honestly, but he does have the rights of a tenant. This doesn't give her the authority to go into that house because he has the rights of a tenant. So it's one of those situations where you just kind of shrug your shoulders. This is clearly a blatant violation of the bond order. I would ask that Mr. Garvin be taken into custody and remain there until such time as the case is resolved. Thank you.
Thank you. Mr. Heasley?
Thank you, Your Honor. In response to that, we would hope that, although it is in the court's discretion to do that, we would hope the court would not. The court itself, although Ms. Martini, as Mr. Lewis indicated, did not testify, the court did elicit information from her directed towards the bench, and that only confirmed the fact that she was involved in the contact as well from her end. That is not uncommon in these types of situations. There are personal ties between the two, and I would fully agree, as the court said a few minutes ago, that no contact means no contact. But Ms. Martini, in response to your own questioning, did indicate her role in this. Mr. Garvin must not have any more contact with her, either personally or by any other means, with Ms. Martini here. I'm sincerely hopeful that that will not happen, and we will have a repeat of this type of incident pending the resolution of the underlying matter. I believe that the officer was asked if there was a repeat incident similar to this one on April 28th, and I do believe he indicated not to his knowledge. We would hope, Your Honor, that Mr. Garvin would not be taken back into custody. He does work. He must leave this woman alone and abide by not just that element of the court's interim orders, but also every other element thereof. So we would hope that he would not be taken back to jail over this, Your Honor. That's all. Thank you very much.
Thank you. This incident happened on April 28th. Ms. Martini, have there been any other contacts since April 28th?
Yeah,
How? So he's emailing you?
Yeah, and I called and I reported it. I talked to Officer Keesman and she had me email pictures.
And do you respond to those emails? I mean, is this a communication?
No.
What don't you get about no contact, Mr. Garvin?
She told my attorney she brought to no contact with the day after.
Yeah, well, she's not ordered to have no contact with you. You're ordered to have no contact with her.
She came in the house the day after court, the initial hearing. I told Philip that. He didn't want to bring it up. He didn't want to have an attitude like we have right now.
Yeah, I've got an attitude because you were a half an hour late. That's why.
That's my fault. That's why there's no contact. She walked in the house. Walked through the back door. I told her there's no contact order, bro. This is my house. I can do what I want to do. This is the 8th.
Well, you know, an eviction, civil, that's a civil matter, and I'm going to be the one having to make a decision on that at some point if that ever comes to before me. I don't want to get into that. And nor do I want to use the criminal process to assist an eviction. Because I've been confronted with that in the past. Look, Mr. Lewis mentioned it. And Officer Pinkett knows full well that our jail is overflowing today. And Mr. Garvin, no contact means no contact. You don't seem to understand that. You're just like questioning, you know.
No, you said no contact. I just told you the day after our original.
I'm telling you, you're to have no contact with her.
She walked in the house. What am I supposed to do? She walked through the back door.
Well, you need to call the police.
Okay.
You need to call the police. And I don't know about these emails. I'm looking at an exhibit of emails clearly showing contact by you outside of her coming into your residence. If you have one more, any bit of contact with her while this case is pending, Mr. Garvin, I'll revoke your bond, you're going to jail, and I don't care. I'll stack you up in bunk beds on top of each other in a jail cell. I don't care. If it happens one more time, that's where you're headed. And Ms. Martini, you need to call the police if there's any further contact, and you need to stay away from him. Understood? We'll set this case for a final pretrial conference in the near future. Bond will continue as previously set, although I am finding that he did violate the conditions of his bond, and I will make clear that if it happens once more, we will revoke it and he'll go to jail.